Let me ask you something. India just passed its first real data protection law, and now there are rules that tell you exactly what to do about it. But here's the thing most people miss. The act and the rules are two different animals, and if you confuse them, you'll build your entire compliance program on shaky ground. That's what this chapter is here to fix. Think of me as the colleague who's already read all the fine print, so you don't have to stumble through it alone. Over the next few lessons, we'll walk through what this playlist sets out to achieve and who it's really meant for. We'll separate what the act does from what the rules do, because that distinction matters more than you'd expect. Then we'll trace the timeline from the 2023 Act all the way to the November 2025 notification so you understand how we got here. We'll unpack that phased rollout, including the 18-month question everyone keeps arguing about. And we'll meet the three players at the heart of all this: the fiduciaries, the processors, and the data principles. By the end, you'll have a mental map of the whole framework. Ready? Let's get started. So let me set the scene. You've probably heard people throw around the phrase DPDP compliance like it's one big checkbox. It isn't. When the rules dropped in November 2025, they turned a fairly short act into a working operational manual. This playlist is about that manual, clause by clause. Now, why does that matter to you? Imagine you're handed a recipe that just says bake a cake. That's the act. The rules are the part that tells you the temperature, the timing, the exact ingredients. Without them, you're guessing. Here's how I like to think about it. The act gives you the principles: your right to consent, your right to erasure, the duty to keep data safe. The rules tell you how to actually deliver on those promises in the real world. Throughout this playlist, we'll go through each major rule the way a compliance officer would on their first week, asking, what does this require, who does it apply to, and what happens if I get it wrong. We won't drown in legal jargon. Instead, I'll keep pulling these rules back down to ground level, with worked examples and checklists you can actually use. Think of this less as a lecture and more as us sitting together working through a real problem one piece at a time. Let's talk outcomes, because that's what really counts. When someone finishes a course, the question they should be able to answer is simple: can I do the job now? So here's what I want for you by the end of this. First, you'll be able to read any one of these rules and immediately know who it binds and what action it demands. That sounds basic, but you'd be surprised how many people freeze when a regulator asks, "Show me your notice." Second, you'll be able to build the actual artifacts: a compliant consent notice, a breach response plan, a retention schedule, not just describe them in theory. Picture this: 6 months from now, your company has a data breach at 2 in the morning. The person who took this seriously is the one calmly pulling up the 72-hour reporting workflow while everyone else panics. That could be you. Third, you'll understand how the pieces connect, because consent, security, retention, and rights aren't separate islands. They feed into each other. And finally, you'll walk away with a roadmap you can hand to leadership. Not vague intentions, but a sequenced plan tied to the rollout timeline. That's the real payoff here. Now you might be wondering, is this actually for me? Let me paint a few pictures and see if you recognize yourself. Maybe you're a privacy professional who's worked with GDPR and you want to map what you know onto India's framework. This is for you, and I'll point out the parallels as we go. Or maybe you're a startup founder who suddenly realized that we collect emails means you're now a data fiduciary with real legal duties. Welcome, you especially need this. Perhaps you're in IT or security and your CEO forwarded you the rules with a one-line message saying, "Make us compliant." I've been there, and we'll turn that vague panic into a concrete plan. Or you could be a lawyer, an auditor, a product manager, anyone whose work touches personal data. Here's the truth: the DPDP rules don't care about your job title. If your organization handles the personal data of people in India, these obligations land on you. What I've tried to do is keep the language accessible enough for a newcomer, but precise enough that a seasoned practitioner still picks up the nuances. So whether this is your first privacy law or your fifth, pull up a chair. There's something here for you. Alright, this is the distinction I promised, and it's worth slowing down for. The Digital Personal Data Protection Act of 2023 is the parent law. It's what Parliament passed. It sets out the big principles, the rights of individuals, the duties of organizations, the powers of the regulator. But, and this is key, the Act deliberately left a lot of blanks. It would say things like data must be erased within a prescribed period without telling you what that period is. The rules fill in those blanks. Let me give you an analogy I find helpful. Think of the Act as the constitution of a company and the rules as the employee handbook. The constitution says employees must behave professionally. The handbook says wear business attire on client days and log your hours by 6 p.m. One sets direction, the other sets detail. So when a rule says breaches must be reported to the board within 72 hours, that 72 hours doesn't appear in the Act at all. It lives in the rules. Here's why this matters for you practically. When you're building compliance, the Act tells you the goal, but the rules tell you the precise enforceable standard. Miss the rules, and you've missed the part regulators will actually measure you against. Let me walk you through how we actually got here, because the timeline tells a story. The Act was passed in August 2023, and then, for a long stretch, not much visibly happened. People kept asking, when do the rules come? When does this become real? That waiting period frustrated a lot of organizations who wanted to prepare but didn't know the specifics. Then in early 2025, a draft of the rules was put out for public consultation. This was a big moment because it gave everyone a preview and a chance to comment. Industry pushed back on timelines, on consent manager mechanics, on all sorts of things. And finally, in November 2025, the rules were officially notified. That's the date that turns theory into obligation. Now, why am I making you sit through dates? Because in compliance, dates are everything. A regulator won't ask whether you understood the spirit of the law. They'll ask what you had in place on a specific date. Think of someone who knew a deadline was coming and started preparing 2 years early versus someone who scrambled the week before. Same finish line, completely different stress levels and outcomes. Understanding this timeline helps you see that you've actually been given runway. The smart move is to use it. Here's where a lot of confusion creeps in, so let's clear it up together. When the rules were notified, they didn't all switch on at once. The framework uses a phased rollout, and the headline figure people quote is 18 months. But what does that actually mean for you? Some provisions take effect immediately on notification. Others, the heavier operational ones, like the consent manager ecosystem and certain fiduciary obligations, are given a longer runway, roughly 18 months, to let the supporting infrastructure get built. Now, about that 12-month question everyone keeps raising. There's been genuine debate about which specific obligations kick in at the 12-month mark versus the full 18, and how transitional periods apply to data you already hold. Let me put it in plain terms. Imagine moving into a new house. Some rooms are ready day one, others need renovation before you can use them. The rules work similarly, staggering the harder requirements. Here's my advice, and I'll repeat it throughout this playlist. Don't treat the longest deadline as your start date. Treat it as your absolute deadline. The organizations that thrive are the ones that map every provision to its effective date and work backwards, not the ones banking on the full 18 months. Let's meet the cast, because every rule we discuss hinges on knowing which role you're playing. There are 3 main characters here. First, the data principal. That's the individual, the actual human being whose data we're talking about. If you've shopped online, signed up for an app, or filled a form, you're a data principal. Second, the data fiduciary. This is the organization that decides why and how personal data gets processed. If you run a business that collects customer data and chooses what to do with it, you're a fiduciary, and most of the legal weight lands on you. Third, the data processor. This is a party that processes data on behalf of a fiduciary following their instructions. Think of a cloud provider or a payroll vendor. Here's a real-world way to see it. Imagine a hospital. The patient is the data principal. The hospital is the fiduciary deciding how records are used. The third-party billing company they hire is the processor. Same data, three different roles, three different sets of duties. Why does this matter so much? Because when a rule says the fiduciary must and you're actually a processor, you need to know whether that obligation is yours or someone else's. Get the role wrong and you'll either over-comply or worse, leave a dangerous gap. Before we dive into the individual rules, let me hand you the map. Because trying to learn these one by one without seeing the whole picture is like memorizing streets without ever looking at the city. So picture the framework laid out in front of us. At the front end, you have the rules about how you collect data fairly. That's the notice rule and the consent rules. This is where the relationship with the individual begins, where you tell them what you're doing and ask permission. Move inward and you hit the rules about protecting data once you hold it. Security safeguards, breach reporting, retention, and erasure. This is the custody layer where you're responsible for keeping data safe and not hoarding it forever. Then there's a layer for special situations, children's data, cross-border transfers, the heightened duties for the biggest organizations. And running through all of it are the rights of the individual and the oversight of the board. Here's how I want you to use this map. As we go through each chapter, keep asking yourself, where does this sit? Is this about collection, custody, or oversight? That mental placement makes everything stick. When the pieces have a home in your head, the whole thing stops feeling like a pile of disconnected rules and starts feeling like a system. And once it's a system, you can actually run it. Let me give you a few practical tips on getting the most out of what's ahead, because how you approach this matters as much as the content itself. First, follow the order, at least the first time through. I've sequenced these chapters deliberately, moving from collection to custody to oversight, so each one builds on the last. Jumping straight to cross-border transfers before you understand consent is like reading chapter 10 of a novel first. You'll be lost. Second, don't just watch, build. Every chapter ends with a worked example and a compliance checklist. Pause and actually apply it to your own organization. When we dissect a consent notice, pull up your real notice and compare. That's where the learning sticks. Third, treat the rhetorical questions I ask as genuine prompts. When I say, so why do organizations struggle with retention? Actually pause and think before I answer. Your brain remembers what it wrestles with. And finally, come back to chapters as reference material. Once the board starts enforcing, you'll want to revisit the breach workflow or the SDF obligations quickly. This playlist is built to be both a course and a desk reference. So that's our foundation. Make sure to subscribe to our channel so you get notified the moment new videos drop, because in the next chapter, we roll up our sleeves and start with Rule 3, the Notice to Data Principles. See you there.